Hi everybody, this is December 4th, 2025, and this is part of my video journal of my recovery from the trauma of watching my little brother, Paul Kierans, 64, with Down syndrome, my last surviving sibling in Greater Vancouver, be locked up by the British Columbia New Democratic Party government, David Eby as leader, for 588 days, and then he had a stroke and died. After he died, the RCMP, Burnaby RCMP Oversight Agency in Ottawa ordered the Burnaby RCMP to follow up on my allegation of secret, fraudulent, forged power of attorney that the British Columbia government created to give Paul the COVID-19 shot on February 1st of 2021. So I had complained to the Burnaby RCMP on August 26th of 2022, and 3 days later, the lawyer for the group home where Paul was living ordered the person that the government had appointed as Paul's guardian, my 82-year-old Catholic nun sister, 4,000 kilometers away in Ontario. The lawyer for the group home ordered her to terminate permanently my visits with Paul. And I tried everything I could think of to restore his visits. I'm a retired lawyer. I practiced family law from 1992 until 2014. I'm also a disabled person. I was in an accident in 2008. So on March 27th of 2024, the oversight agency demanded that the Burnaby RCMP reopen the investigation into this fraudulent forged power of attorney. And Paul had some kind of stroke on April 13th of 2024, and he died on 10 days later at Burnaby Hospital on April at 10:15 on April 23rd of 2024. I believe that when my sister, the nun, she flew in a couple of days after Paul had a stroke. They didn't tell me until she was in town. So he laid alone at Burnaby Hospital for 2 days. But when she flew in, she ordered the doctors to move Paul to the hospice ward. And although he appeared to me to be recovering, when I walked into the room, once he had the stroke, I was allowed to visit him in person for 10 minutes a day, supervised by this nun from Ontario. Although I sat in the hallway for 10 to 12 hours a day while he was in the hospital. But when she found out that the Burnaby RCMP had reopened the investigation into her power of attorney over Paul, I believe that she told the doctor, the treating doctor, to kill him. I watched with my own eyes. He had an oxygen mask, like a ventilator, and he was quite active. In fact, he was so active they tied one of his hands down, but he grabbed my hand and squeezed it so tight when I said my name, and he made good eye contact. He grabbed a book out of my hand, turned the pages perfectly. But what she did was she ordered the doctor to remove his ventilator and to sedate him to death. I could see this, and I complained to the nurse. I said, I think he's being over-sedated. And the nurse said, we'll make our own judgment about that. So if you can imagine, I watched my last surviving sibling in Greater Vancouver be killed right in front of my eyes. And I believe it was because the nun thought that would that would be the end of the investigation into her power of attorney over him. So I had uh, appealed the appointment of the nun as Paul's guardian, and that hearing took place on we got the decision on March 28th of 2024, and my appeal of the appointment of the nun as Paul's guardian was dismissed. And then, as I said, he had some kind of stroke on April 13th, a few days later. But when she found out that the Burnaby RCMP were ordered to reopen the investigation into her power of attorney, that's when she brought on an application to have me declared a vexatious litigant. So that is a very unusual and rare designation in Canadian law, which takes away a person's access to the Canadian courts. So everyone, even those ostriches, had access to the Canadian courts. But this application took away my access to Canadian courts. And it was most irregular. The hearing took place after Paul died. It took place from November 18th to November 22nd of 2024. And I had told the judge, and I provided her with documents showing that I'm disabled with a potentially fatal cardiac condition, and I'm only allowed by my doctor's order to be in court for 2 hours per day. But the judge went beyond. She went for 2.5 hours and then for 2 full days. She said I could sit in the gallery. So, and at the end, on November 29th of 2024, she wrote reasons for judgment, designating me permanently a vexatious litigant and taking away my access to Canadian courts, the regular access to Canadian courts. So I've appealed that decision, and to the Court of Appeal of British Columbia, and my application to set aside the designation of being a vexatious litigant was dismissed. And so I applied for permission to appeal the designation as a vexatious litigant to the Supreme Court of Canada in Ottawa. And it's very rare that, or relatively rare, that you're granted permission to appeal to the Supreme Court of Canada in Ottawa. It has to be an important issue of national importance, which I believe this is. The judge transgressed my rights under Section 7 of the Canadian Charter of Rights and Freedoms, which states that everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except for in accordance with the fundamental principles of justice. So the judge put me and my health and my life in jeopardy by going past my 2-hour time limit stipulated by my family doctor and my cardiologist. So my appeal of the designation of me as a vexatious litigant everything was filed on September 3rd of 2025, so just this past September, and I haven't heard back from the Supreme Court of Canada. So I have been asking people just to call and write and ask about the status of my application for permission to appeal. And my Facebook friend, Sue Morley, actually wrote them an email, and they responded back to her, and they said that I hadn't filed the oral reasons for judgment. You have to pay. Excuse me, I've got a bad cold. You have to file with the court any oral reasons for judgment. So what the judge says was her reason for deciding things the way she did. And I had ordered them and paid for them I think it was $150, and I had filed them back in September, but they must have mislaid them. So this, if Sue Morley in Australia hadn't inquired about the status of my application for leave to appeal this designation as a vexatious litigant, if she hadn't inquired, I wouldn't even know that they had misplaced this document that I had filed with them. So I'm asking you to please take a moment to call the registry. I'll put the number, the telephone number, and the email address in the description box for this video. So please take a moment to call them and ask about the status of my application for leave to appeal. Every little bit helps. And as I said, if my friend in Australia hadn't contacted them, I wouldn't even know that they were missing a document that I had filed in September as part of my application. And more importantly, pray for me. This is a very important issue. This judge in Vancouver put my life in jeopardy and took away my access to Canadian courts, which everyone, it's a fundamental principle of justice that everyone should have access to Canadian courts. And what happened was the designating me as a vexatious litigant discredited me as a witness for the RCMP, so I never heard from the RCMP again. After I was designated a vexatious litigant, you can imagine I become toxic, and they never contacted me again, and they never did follow up on the investigation into the fraudulent forged power of attorney over my little brother that led to him being locked up for 588 days and 178 missed visits. So please take a moment to call the reception at the Supreme Court of Canada or email them and ask about the status of the case Walker versus Kierans, file number 41902. All the information will be in the description box for this video. Thank you, everyone. I love you all.